When we think about a country going to war, it's pretty easy to view it as this massive, abstract state action.
Right, like a faceless machine.
Exactly.
Yeah.
But international law actually makes it incredibly personal. So today, we're diving into a breakdown titled Anatomy of a Crime.
Yeah, we're unpacking Article 8 bis, which outlines the crime of aggression.
And our mission in this exploration into the source material is to really understand the high legal threshold required to actually prosecute state leaders for the illegal use of force.
It's a really fascinating area of law because it's designed to pierce that state shield, to find the individuals responsible. But what's crucial here is that this isn't a crime just anyone can commit. It is strictly a leadership crime.
Okay, so this is essentially a C-suite crime.
Yeah, that's a great way to look at it.
Because if you're a soldier on the ground just following orders, or maybe a mid-level officer, Article 8 bis doesn't even touch you.
Not at all. To be a perpetrator, you have to be in a position to effectively exercise control over or direct a state's political or military action.
So the people at the very top.
Well, it's actually broader than just the person at the very top. We're talking about anyone with the power to steer the ship. So whether they're planning the invasion in a basement or signing the final execution order.
Okay.
If you're in the room where it happens across the 4 stages.
Which are planning, preparing, initiating, or executing. Right?
Exactly. If you're involved in those, you're on the hook.
Okay, so the who is restricted to the architects, but the act itself, I mean, that seems like it could be a complete legal minefield.
Oh, absolutely.
Because the framework defines an act of aggression as the use of armed force against another state's sovereignty, which is basically their right to say, you can't come in here.
Right. Or their territorial integrity.
Yeah.
And obviously it has to be inconsistent with the UN Charter.
But is every minor border scuffle a crime of aggression? Like, what if a drone accidentally drifts over a border while chasing a suspect?
That is exactly where the manifest threshold comes in. You can think of it as the anti-nuisance clause of international law.
Anti-nuisance, I like that.
Yeah, without it, that single drifting drone could trigger a global legal crisis. So Article 8 bis includes this really high bar to ensure the law is reserved for only the most blatant violations.
So it's essentially a seriousness filter, but how do you actually measure seriousness in a courtroom? Because that feels really subjective.
It does, but the law actually uses 3 objective criteria: character, gravity, and scale. And they have to work together.
Okay, so how does that look in practice?
Imagine a few soldiers taking a wrong turn and crossing a line. That has low scale and low gravity. But an invasion involving thousands of troops and airstrikes, that has the scale and the gravity.
And then character is the why. Like, is it a temporary blockade or a full-scale annexation?
Precisely. To trigger a prosecution, it has to be big enough, mean enough, and obviously illegal enough that literally no one can call it a mistake.
Okay, that definitely clears up the act. But I'm still stuck on the intent part. Surely a leader could just hire a fleet of expensive lawyers to argue that, well, in their personal opinion, the war was totally legal under some obscure reading of the UN Charter.
You'd think so, yeah. That's a super common assumption.
Because wouldn't that lack of criminal intent protect them? In most criminal cases, you have to prove the person actually knew they were breaking the law.
Not here. The framework actually sets a trap for that exact excuse. The mental element is focused strictly on the awareness of factual circumstances.
Wait, really?
Yeah, the prosecutor does not have to prove the leader performed some complex legal evaluation. If the leader knew the facts, like that they were ordering an army across a sovereign border to seize territory, the mental requirement is checked off.
Oh, wow. That's a huge aha moment. It's fact over interpretation.
Exactly.
So a leader cannot use legal ignorance or creative lawyering as a shield. If the objective facts show a manifest violation, and the leader knew those facts, they are responsible. Their personal judgment of the law is just irrelevant.
Precisely. It keeps the focus on objective reality, what actually happened on the ground, rather than the legal gymnastics of the people in power.
I mean, if you're a listener wondering why this matters, it's a framework built to hold the actual architects of violence personally accountable for the reality of their actions. It tells the people holding the reins that their personal opinion on the law doesn't matter nearly as much as the physical scale of the force they unleash.
It's entirely about protecting the global order, ensuring that the people who direct the state can't just hide behind the state.
It's a high bar, but a firm one. But before we wrap up, here is a provocative thought to leave you with. If the manifest threshold relies so heavily on objective markers like scale and gravity, What does that mean for the future of gray zone conflicts?
Oh, that's a great question.
Right. What happens when a state uses force in ways that are intentionally small-scale, digital, or ambiguous just to stay under that legal radar? It's definitely something to think about as the nature of conflict continues to evolve.
So let's talk about one of the most serious, but also one of the most misunderstood crimes in international law, the crime of aggression. We're going to unpack what it actually is, who can be held responsible for it, and, why it's so incredibly hard to prosecute. It really all boils down to this one question, right? When one country illegally invades another, who actually gets the blame? I mean, is it the soldier on the front line? Is it the general giving the orders? Or is it someone else entirely? Let's dive into the legal framework that tries to answer that. All right, so first things first, what do we even mean when we say the crime of aggression? What does that look like in the eyes of international law? Okay, I know that's a whole lot of legal jargon, so let's just boil it down. It's basically about a top-level leader launching an act of aggression that is so big, so serious, that it's a manifest violation of the UN Charter. Now, that word manifest, that's the absolute key to this whole thing, and we're going to get into exactly what that means in just a bit. So, who can actually be charged with this? This is where we hit a really crucial point in international law. Yeah, the first thing you've got to understand is that the crime of aggression is not for the average soldier. It's specifically designed to hold the people at the very top, the political and military leaders, accountable. That's why you'll often hear it called the crime of leadership. And the law is pretty specific about who fits that bill. We're talking about the people who can actually control or direct what a country does, politically or militarily. So, think heads of state, top government ministers, maybe some very senior military commanders. They're the ones with the real power to plan and start a war. Okay, so we've established who can be prosecuted. Now let's look at what they have to do, because it all starts with an act committed by the state itself. So for this crime to even be on the table, a country has to commit an act of aggression. And what's that? It means using its military against another country in a way that stomps all over its sovereignty, its borders, or its political independence. Basically, it's the illegal use of armed force. But here's where it gets tricky, and this is super important. Not every illegal use of force is going to count. The bar for this crime is set really, really high. Remember that word, manifest? Well, here it is again. The violation of the UN Charter has to be manifest. And what's crucial is that this is an objective standard. It's not about what some leader personally believed. It has to be so clear, so obvious, that any reasonable person looking at the situation would go, yep, that's a massive violation. That objectivity is key. And this comparison makes it super clear. Look, on the left, a standard violation might be something like a small border skirmish, but a manifest violation on the right, that's a whole other beast. It's judged by its character. We're talking a full-scale invasion, not a minor incident. It's judged by its gravity, the terrible consequences, like huge numbers of civilian deaths. And it's judged by its scale, the sheer size of the military force involved. So this kind of raises a pretty logical question, doesn't it? To be guilty of this crime, does a leader need to have a law degree? Do they need to sit down and conclude, yes, this is, legally speaking, a manifest violation? And the answer is a clear no. The standard isn't about their personal legal opinion, it's about whether they knew the facts on the ground. The question the court asks is this: was the leader aware of the circumstances that made it a manifest violation? Did they know about the massive scale of the invasion, the nature of the attack, the devastating consequences that were likely to follow? That's what matters. Okay, so we've looked at the leader, the state's action, and the super high manifest threshold. So let's put all those pieces together now and see the complete legal test. So here it is. This is the big takeaway. To actually prove the crime of aggression, you have to check all 4 of these boxes. 1, a top leader planned or carried out the act. 2, their country illegally used its military. 3, that act was a manifest violation when you look at its character, gravity, and scale. And finally, number 4, the leader knew the facts that made it so bad. You need all 4. And all of this leaves us with a really big, thought-provoking question. For most of history, starting a war was just a political move, not something you could be arrested for. So now that we have this clear global definition of the crime of aggression, how does that really change things for world leaders? How does it change the whole calculus of going to war?
I want you to picture a scene that, we see on the news constantly. It's chaotic, There's smoke, there's debris. You see soldiers moving through a city, or maybe tanks rolling across a field. It's the visceral reality of war. And when we look at that footage, our eyes are naturally drawn to the action on the ground. We look at the soldier pulling the trigger.
Yeah.
We look at the tank commander. We're looking for the immediate cause of the destruction.
That's the human response, isn't it? We look for the person holding the weapon.
Right. But today, we're going to do something a little unnatural. We're going to look away from the soldier. We're going to look away from the battlefield entirely. We're going to zoom out, and then we're going to zoom way, way up.
Miles away.
To a quiet office, probably thousands of miles away from all that smoke. We're looking for a person in a suit, sitting behind a big desk, maybe looking at a map.
We are looking for the architect.
It's exactly, the architect. Because today, we aren't talking about war crimes in the, let's say, the traditional sense, shooting prisoners or targeting civilians. We are talking about the crime, the crime of starting the war in the first place.
The judges at Nuremberg called it the supreme international crime, which is quite a title.
It is.
They said it contains within it the accumulated evil of the whole.
The accumulated evil of the whole. That is such a heavy concept. And to understand how international law tries to pin that specific guilt on a single human being, we are looking at just one document today.
And it's not a long one.
No, it's not a book. It's not an article. It's a legal text. We are doing a forensic deep dive into the legal elements of the crime of aggression, specifically Article 8 bis of the Rome Statute.
And I know. Article 8 bis sounds like the driest possible thing we could talk about. It sounds like a tax code or something.
It really does. I saw the title and I thought, oh boy.
But you have to view this document differently. You have to see it as like the rules of the game for the highest stakes of geopolitics. This is the manual that tells us when a president, a prime minister, or a general stops being a political leader and becomes a criminal.
It's the boundary line.
It is the boundary line between statecraft and felony.
And what really struck me reading through this source material is how incredibly specific it is.
Yeah.
I think the average person, and I include myself in this, has this vague idea that aggression just means, well, being the bad guy who started it.
Right. It's just a vibe.
It's a vibe.
Yeah.
But the law doesn't work on vibes. It works on checklists.
It has to. I mean, think about it. If you are going to put a head of state, a sovereign leader, in prison for the rest of their life, you cannot be vague. You need a mechanism that is as watertight as humanly possible.
And that's what this Article 8 bis attempts to be. It's a filter.
A very fine filter.
Yeah, it filters out the noise, the propaganda, the chaos of war, and it tries to distill the guilt down to 4 specific, testable elements.
And that's our roadmap for this deep dive. We're going to deconstruct this crime piece by piece.
So we'll start with the who, because it turns out very, very few people can actually commit this crime. Then we're going to look at the act, what specifically counts as aggression. After that, we'll get into the threshold.
How bad does it have to be?
Exactly. And then finally, we're going to spend some real time on what I think is the most fascinating part.
The mindset.
The mens rea. The guilty mind. That's where the document gets truly actually sailing safe.
Ooh, fascinating.
And frankly, that's where the trap snaps shut.
Okay, so let's start at the top. The who. The leadership clause. I'm looking at element 2 in the source text. It says, the perpetrator was a person in a position effectively to exercise control over or to direct the political or military action of the state.
This is what lawyers call the leadership clause. And it is, and this is important, it's unique in international law.
How so? What makes it so different?
Well, think about almost any other crime. Murder, theft, arson, or even other war crimes like torture.
If a private soldier on the ground tortures a prisoner, that soldier is liable. If a sergeant orders a massacre, that sergeant is liable. Rank doesn't shield you, but, and this is a key, lack of rank doesn't save you either. Anyone can be a war criminal.
But not anyone can be an aggressor.
Precisely. The crime of aggression is an exclusive club, a very exclusive one. It effectively grants immunity for this specific crime to 99.9% of the military and the government.
That's a huge number.
It is. If you are a colonel commanding a regiment and you invade a country because you are ordered to, you cannot be charged with aggression. The law says you simply don't have the agency. You're a tool, not the user of the tool.
That's a crucial distinction. It creates this pyramid of responsibility, and it's only looking at the very, very top.
The apex.
But I want to push on this definition of position a bit. The text uses the phrase effectively to exercise control. Why that specific adverb? Why effectively? What work is that word doing?
It's doing all the work. Because the law is allergic to fiction. It knows that organizational charts, well, they lie sometimes.
Right. In many countries, the person with the title, the president, the monarch, whatever, might just be a figurehead. If you have a constitutional monarch who signs a declaration of war because it's their ceremonial duty, but they actually have zero power to say no, are they the aggressor?
Well, on paper, their signature's on the document, so you'd think, yes.
You would think. But the word effectively cuts right through that. It asks, who actually has the juice? Who has the power to make the machinery of the state move? If the monarch is a puppet, the law ignores them and looks for the puppet master.
So it's hunting for the real decision maker, regardless of their business card.
Precisely. And this cuts both ways. You could have someone with no official title at all, a special advisor, a powerful party leader, maybe even a wealthy donor in a state that's been, completely captured by private interests.
A gray cardinal type figure.
Yes, exactly. If that person can effectively direct the military action, they are the perpetrator. The law pierces the veil of bureaucracy to find the person with their hands on the controls. That reminds me of the whole shadow commander concept we sometimes see in history. The person whispering in the king's ear who's really running the show.
It's the Rasputin clause, essentially. If Rasputin is the one actually directing the armies, Rasputin is the one who's going to The Hague, not the Tsar.
Now, the text also links this control to political or military action. That little word "or" feels really significant. It seems to broaden the net.
It does. It recognizes that state power, stands on two legs. You have the civilian apparatus, the suits, presidents, prime ministers, chancellors. They make the political decision to use force.
Okay.
But you also have the military apparatus, the uniforms, the chiefs of staff, the high command, the people who actually execute it.
But doesn't that create a potential conflict? I mean, usually, in a democracy at least, the military is subordinate to the civilian government. So if a general is ordered by the president to invade, and he does it, is he really directing the action? Or is he just following orders like that colonel we mentioned earlier?
That is where the high command argument comes in, and it's a very important gray area. The thinking is that at a certain level, usually the very top, like the Joint Chiefs or the equivalent, you are no longer just an implementer, you're an architect.
You're not just following the recipe, you're helping write it.
A perfect analogy. You are advising on feasibility, you are drawing up the actual plans, you are shaping the options presented to the political leader. If a general says, Mr. President, we can take this country in 3 days, and here's exactly how, and the president says go, well, they're both effectively exercising control. They are partners in the enterprise.
So there's a floor to this liability, a level below which you're just a cog in the machine.
Right.
But the ceiling is shared. It can be a civilian or a military leader or both.
Exactly. It captures the boardroom where the decision happens. It doesn't matter if you are wearing a tie or a uniform. If you are in the room where it happens and your voice, your decision has real weight, you are potentially liable.
So it effectively removes the "I was just a soldier" defense for the top brass.
It does. That defense works for the captain. It does not work for the field marshal.
Okay, so we've established the who. It's the bosses, the people with their hands on the joystick of the state. Now we need to talk about the act. What are they actually doing that constitutes a crime?
Right.
The source text in element 1 lists 4 verbs: planned, prepared, initiated, executed.
And again, don't just gloss over that list. Each word is chosen carefully, and the sequence matters a great deal.
Okay, well, initiated and executed seem pretty obvious to me. That's the war starting and then the fighting of the war. But planned and prepared, that feels like we're moving the timeline back significantly.
We're moving the timeline back from the battlefield to the briefing room. Think about modern warfare. You don't just wake up on a Tuesday and decide to invade your neighbor.
No, it takes massive logistics, months of work.
It takes months, sometimes years. You have to move fuel reserves. You have to build field hospitals near the border. You have to draft the battle plans, which is a huge undertaking. You have to stockpile ammunition. You might even have to condition your population with propaganda to get them ready for it. All of that is preparation.
So the crime of aggression doesn't start when the first tank crosses the border.
No. Under this definition, the crime can begin in a conference room months before a shot is ever fired. If you are, say, the Minister of Logistics, and you spend 6 months engaging in the preparation of what becomes a manifest act of aggression, ordering the fuel, moving the blood supplies, contracting the transport, you are participating in the crime.
That's terrifying for the bureaucracy. It criminalizes the spreadsheet work if that work is directed toward an illegal war.
It does. It has to. It removes the ability to say, well, I just handled the supply chain. If you handle the supply chain for a manifest act of aggression and you are in a leadership position to do so, you prepared the crime.
So what if, here's a hypothetical, what if the war gets called off? Say I spend a year planning an invasion, I buy the weapons, I draw the maps, I do everything. And then at the last minute, the president gets cold feet and cancels the whole thing. Did I still commit a crime?
That's a fascinating legal edge case and honestly a bit of a gray area. Generally, for the crime of aggression to be prosecuted under this specific statute, the act of aggression, the use of force, usually has to occur. Attempted aggression is much murkier water legally.
Okay.
But the whole point of including planned and prepared is to ensure that if the war does happen, prosecutors can reach back in time and grab people who built the engine, not just the person who turned the key.
I see. It casts a net over the entire timeline of the catastrophe, not just the moment of impact.
Correct. It's about the whole process.
Now let's look at what the aggression is actually against. Element 3 gives us the core definition. The use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state. I feel like I've heard these three phrases together before. They feel like the holy trinity of statehood.
They are. Sovereignty, territorial integrity, political independence. These are the three pillars that the entire system of international law is built to protect. Without them, there's no order.
I want to parse these because they sound a little bit synonymous, but I have a feeling they aren't. Let's take territorial integrity first. That seems the most tangible, the most physical.
It is. That's the dirt. That's the map. If you send troops across a recognized border to seize land, if you annex a province, if you forcibly move the border posts, you are violating territorial integrity. You are physically breaking the container of the state. It's the most straightforward one.
Okay. So what about sovereignty? How's that different from the land itself?
Sovereignty is the right to rule within that land. It's the authority of the state over its own domain, its own people, its own laws. You could violate sovereignty without actually taking any land.
How? Give me an example.
Okay, for example, if you fly military aircraft at low altitude over another country's capital just to intimidate them, or if you send in special forces to kidnap a dissident off their streets, you aren't trying to keep the land, but you are sending a very clear message. Your laws don't apply here. My power overrides yours. That is a direct attack on their sovereignty.
Got it. And the third one, political independence. This feels the most abstract of the three.
It can be, but it's absolutely vital. This is about agency. It's the right of every state to make its own choices, who to ally with, who to trade with, what kind of government to have. If state A uses armed force or the threat of it to coerce state B into changing its government or abandoning a treaty or changing a domestic policy, that is an attack on its political independence.
So if I were to say, look, I'm not going to take your land and I'm not going to rule you, but I am going to bomb your ports into rubble until you fire your prime minister and install someone I like.
That is a classic textbook violation of political independence. You are using force to decapitate their free will as a nation.
And the text includes this kind of catch-all phrase at the end, or in any other manner inconsistent with the Charter of the United Nations.
That is the anchor. That phrase anchors this whole definition to the foundational document of the modern international order.
The UN Charter.
The UN Charter is the constitution of the planet, effectively. And Article 2, Paragraph 4 of that charter is the golden rule. Do not use force against other states, period.
But there are exceptions.
There are only two recognized exceptions. Do you know what they are?
Well, self-defense has to be one. If you're attacked, you can fight back.
Right. That's Article 51, the inherent right to individual or collective self-defense. That is not aggression, that is survival.
And the second one, is it getting permission from the UN Security Council?
Exactly. If the UN Security Council passes a resolution under Chapter 7 of the Charter saying, this situation is a threat to international peace and security, and we authorize the use of force to fix it, then it is legal.
And that's it. Those are the only two.
That's it. Anything else, any use of force that isn't clearly self-defense or explicitly UN authorized, it is inconsistent with the Charter.
So that's the baseline. If you step outside those two very narrow safe harbors, you are swimming in criminal waters.
You are, but, and this is a massive but, not every illegal use of force, not every violation of the Charter is the crime of aggression.
Right, and this is where I think the listener might be surprised. Because we hear about border skirmishes all the time. A fighter jet gets shot down over disputed airspace, a patrol gets lost, and there's a firefight. Those are technically uses of force. They're inconsistent with the charter.
They are.
But are we going to haul the president of a country to The Hague for a border mix-up?
No. And this brings us to Section 3 of our deep dive, the threshold. The law includes a crucial filter to separate minor incidents from major crimes.
And the word used in the text is manifest.
A manifest violation of the charter. It's not enough for it to be a violation, it has to be a manifest one.
And to show you what manifest means, Element 5 lists 3 specific metrics to measure it: character, gravity, and scale.
Character, gravity, scale. This is how the law weighs the sin.
Let's break them down. Scale seems like the most straightforward. It's a numbers game, right?
It is, largely. How many troops are involved, how many tanks, how many square kilometers of territory are seized. If a single platoon of 30 soldiers accidentally crosses the border for an hour, that is a violation, but the scale is tiny. If an entire army group of 200,000 soldiers crosses, the scale is high. It's a quantitative measure.
Okay, that makes sense. Then gravity, how is that different from scale? It sounds similar.
Gravity is qualitative. It's about the intensity of the impact and the severity of the consequences. You could have a relatively small-scale attack, say, a single precise missile strike, but if that strike hits the country's only nuclear power plant or destroys the parliament building while it's in session.
The gravity is enormous.
Exactly. It destabilizes the entire state. It causes massive human suffering or political chaos. A small act can have immense gravity.
So scale is the size of the fist. Gravity is where the punch lands and how much damage it does.
That's a very good way to put it. And then you have the third one, character.
Character. That's the most nebulous sounding one.
It refers to the nature of the operation itself. The intent you can infer from the actions. For example, is it a surprise first strike attack out of the blue? Is it a full spectrum invasion with the stated goal of conquering the country and erasing it from the map?
Versus,
say, a limited incursion to create a buffer zone on the border, or an action to rescue your own nationals who are trapped. The character of a full-blown war of conquest is fundamentally different from the character of a limited border skirmish, even if the scale is similar.
So to be the crime of aggression, you need to ring the bell on these 3 things. You need to combine them, and the result has to be a manifest violation.
Yes, it has to be clear, serious, and undeniable.
But here's the problem I have with words like manifest or serious. They feel subjective, don't they? I mean, if I'm the invading leader, I might say, well, to me, this is just a minor police action. It's not a big deal. It's not serious. Who gets to decide?
And that is exactly why the introduction to the text, the notes that explain the elements, includes point 3. It's a critical sentence.
I have it right here. It says, the term manifest is an objective qualification.
Objective. That is the single most important word in that entire section.
Unpack that for us. What does objective mean in a courtroom setting like this?
It means the perpetrator's opinion is completely and totally irrelevant. It means we don't ask the dictator, did you think this was a manifest violation? We ask a hypothetical, reasonable observer. We look at the facts on the ground.
So it's verifiable by outside evidence, not by the leader's internal feelings or justifications.
Exactly. Imagine you burn down a house.
Okay, I'm an arsonist again.
You're in court, and you stand before the judge and you say, Your Honor, in my personal opinion, this wasn't a big fire. It was just a small, cozy fire that happened to consume a building.
Right.
The judge doesn't care about your opinion. He looks at the pile of ash. He looks at the fire department's report. He says, objectively, you destroyed the structure. The destruction is manifest. Your opinion is worthless.
So this is designed specifically to prevent leaders from gaslighting the international community.
It is its primary function, yes, because leaders always minimize their actions. They always call invasions interventions. They call wars special military operations. The objective standard is designed to cut through the branding and look at the reality of the violence.
It says, we don't care what you call it. We care what it is.
Precisely. And that brings us to the part of the deep dive that I found the most intellectually naughty, the part that really made my head spin.
Section 4, the mindset, or as the lawyers say, mens rea, the guilty mind.
This is the brain melter. This is where the text gets incredibly subtle, but also, in my view, incredibly ruthless.
So usually for a crime, you have to know you're doing something wrong, right? You need to have criminal intent.
Generally, yes. The concept of intent is central to criminal law.
So let's look at what the perpetrator needs to know here, according to the text. Elements 4 and 6 talk about being aware of factual circumstances.
Right. Element 4 says the perpetrator was aware of the factual circumstances that established the use of force was inconsistent with the charter. And element 6 says they were aware of the factual circumstances that established the manifest violation.
The key phrase in both of those is factual circumstances.
It is. This means the leader must know what is happening on the ground. They need to be aware of the facts. I am ordering 500 tanks to cross the border. I am ordering the bombing of the capital city. I know this is not an act of self-defense. They need to be aware of the scale, the gravity, and the character of their own actions.
That seems like a pretty low bar for a world leader. I mean, if you're the president, you generally know where your army is and what it's doing.
Usually, yes. But it does protect the leader who is genuinely deceived. Suppose a president orders a large-scale training exercise near the border. His rogue general, on his own initiative, decides to invade instead, and he lies to the president. He says, "Mr. President, everything is fine. We're staying on our side of the border, sir."
Okay.
The president thinks the tanks are at home base. The facts are that the tanks are invading the neighbor. The president does not know the factual circumstances of the invasion. Therefore, he is innocent of aggression. The rogue general is the guilty one.
Okay, that makes perfect sense. You can't be guilty of a war you didn't even know was happening. But here is the massive twist. Introduction point 2.
Go on, read it. It's a killer.
There is no requirement to prove that the perpetrator has made a legal evaluation as to whether the use of armed force was inconsistent with the Charter of the United Nations.
And point 4 says the exact same thing about the manifest nature. No requirement to prove a legal evaluation.
This just stops me in my tracks.
Yeah.
No requirement to prove they made a legal evaluation. Does that mean they don't have to know that what they're doing is illegal?
That's exactly what it means.
But hold on. That seems to contradict the whole idea of a guilty mind.
If I genuinely believe my war is legal, let's say I have a team of the best government lawyers, and they write me a 100-page memo saying, "Mr. President, under a novel interpretation of international law, you are totally allowed to do this. How can I have criminal intent? I think I'm following the law."
And the statute says, it does not matter what you think the law is.
That feels incredibly harsh, doesn't it? It feels harsh, but think for a second about the alternative. If we required the prosecution to prove that the leader knew their actions were illegal, what would every single leader on earth do?
They would just get a lawyer to write a memo saying it's legal.
Exactly. They would generate a paper trail of self-justification. They would lawyer shop until they found someone to write a 500-page opinion saying, actually, bombing this country is perfectly legal because of this obscure precedent from 1842 and so on. Then, in court, they would waive that paper and say, see, I made a legal evaluation that I was innocent. Therefore, I had no criminal intent. Case closed.
It would be a get-out-of-jail-free card for any leader with a decent lawyer.
It would make the crime completely impossible to prosecute because no world leader ever admits, probably not even to themselves, I am knowingly breaking the supreme law of the planet. They always construct a justification. They have to.
So the law just removes that hiding spot. It takes it off the table entirely.
It obliterates it. It creates a firewall. It separates knowledge of the facts from one's opinion on the law.
Let's go back to that car analogy we discussed before we started recording, because that really helped it click for me.
Okay, so you're driving your car, you're going 100 miles per hour in a 25 mile per hour school zone.
Right. I'm driving very, very fast.
Do you know the factual circumstances?
Yes. I can see the speedometer in front of me says 100. I can see the flashing school zone sign out my window. I know the facts of what I'm doing.
Okay. Now let's say you have a very strange personal interpretation of the traffic laws. Let's say you genuinely believe that if you are late for a very important deep dive recording, the speed limit doesn't apply to you. That is your legal evaluation.
My personal legal theory is that my podcasting is more important than traffic laws.
Correct. You get pulled over, you tell the police officer, "Officer, I know I was going 100, I knew the facts, but I did not have a guilty mind because I had made a legal evaluation that I was allowed to do it."
The officer's going to laugh at me before writing the ticket.
The officer is going to hand you a very large ticket. Because your error in interpreting the law is not a defense. Ignorance of the law or a creative interpretation of it is no excuse. You knew the facts, speed plus location. The law says those facts equal a crime. Your opinion on the law is irrelevant.
So applying this to a world leader and a war.
If a leader knows the facts, I am invading my neighbor. It is a massive invasion involving thousands of troops. It is not in self-defense. And those facts objectively constitute a manifest violation. They are guilty, period. Even if they convinced themselves it was a righteous crusade, even if they had a stack of legal memos a foot high telling them it was perfectly legal.
That is a trap. That is a very well-designed legal trap.
It has to be. It forces leaders to be responsible for reality, not for their own spin. The law says, you are the architect of this war. You are responsible for the structure you have built. If you have built a criminal war, you are a criminal. We don't care what you thought you were building.
Wow. That creates a fascinating dynamic. It means that ignorance of the law is no excuse, applies even at the highest, most complex level of geopolitics.
Especially at that level, the assumption is, you are a head of state. You have advisors. You are expected to know the UN Charter, the most basic rule of the road.
So, we've disassembled the machine. We have all the parts on the floor. Let's try to put it back together in Section 5. Let's synthesize this and look at the full anatomy of accountability.
Let's do it. Let's imagine we are prosecutors at the International Criminal Court in The Hague. We have a former head of state in the glass booth. How do we build a case to get a conviction under Article 8 bis? It's a 4-step checklist.
Okay, step 1, the who. The status.
First, we check their status. Were they a leader? Did they have effective control over the state's political or military action? If they were a foot soldier or a mid-level bureaucrat, case dismissed. If they were the president, the prime minister, the defense minister, or that Rasputin-like shadow commander, we check the box and proceed to step 2.
Step 2, the act, the action.
Did they plan, prepare, initiate, or execute the use of armed force against another state? We look at the timeline, the documents, the orders. Did they order the fuel reserves moved? Did they sign the invasion decree? If we can prove they did one of those 4 things, we check the box and proceed.
Step 3, the threshold, the quality of the act.
We look at the war itself. We apply that cold, objective test. Was it a manifest violation of the UN Charter? We present evidence of the scale, the gravity, and the character of the attack. We argue that any reasonable observer would see this not as a mere incident, but as a major crime. If the judges agree, we check the box and proceed to the final step.
And finally, step 4, the mindset, the knowledge.
This is the final nail. We look at the defendant's knowledge. Were they aware of the facts that we established back in step 3? Did they know about the scale of the invasion? Did they know about the gravity of the bombing? Did they know it wasn't self-defense?
And what happens when their defense lawyer stands up and says, but my client had a legal opinion from the Ministry of Justice saying this was all perfectly legal?
We simply stand up and cite introduction, point 2 and point 4. We say, objection, your honors, irrelevant. We ask the court to disregard their legal opinion entirely. If they knew the facts, the lock clicks shut.
Guilty of the crime of aggression.
Guilty.
It's incredibly systematic. When you lay it out like that, it feels less like a messy political accusation and more like a logical proof.
It is a forensic tool. That's the goal. It's designed to cut through the fog of war and political rhetoric to find the point of origin for the catastrophe.
There is one more little piece of the source text we haven't touched on yet, which I think kind of seals the whole deal. It's introduction point 1.
Ah, yes. It is understood that any of the acts referred to in Article 8 bis, paragraph 2, qualify as an act of aggression.
At first glance, it sounds like a tautology. An act of aggression is an act of aggression. Why is that even in there?
It's a closing of the loop. It's there to create absolute certainty and remove any wiggle room. It basically says, if the act fits the description in the text, if it's an invasion, a bombardment, a blockade, it is an act of aggression. There is no maybe. There is no, well, it depends on the context or the vibe. If it checks the boxes on the list, the label applies. It's definitional.
So we've unpacked the law. And on paper, it looks incredibly robust. It looks terrifying for a potential aggressor. But I have to play devil's advocate for a moment as we wrap up.
Please do.
We live in the real world. And in the real world, objectivity is a very scarce resource. We talked about the hypothetical objective observer who gets to decide if a violation is manifest. Who is that person in reality?
That is the million-dollar question, isn't it? That's the entire challenge of international justice.
Because in any major geopolitical crisis, you will have half the world saying, this is a manifest violation, look at the scale, it's undeniable. And the other half will be saying, no, this is a necessary humanitarian intervention. The gravity is low because they are saving lives. Everyone has their own observer.
You are hitting on the fundamental weakness, or perhaps the challenge, of all international law. The text gives us the formula. Gravity plus scale plus character must equal manifest. But it doesn't give us the calculator.
And who gets to punch in the numbers?
Is it the judges at the ICC? Theoretically, yes, but judges are human. They come from different countries, different legal traditions, they exist in a political context, and let's be honest, the old saying is true. The winners of wars rarely stand trial for starting them. This law is perfect on paper, but its application relies on political will to even get the defendant into the courtroom in the first place.
So the objective observer is an ideal that we strive for, but maybe never fully reach in the messy world of politics.
It's an aspiration. But the fact that we have the definition, the fact that Article 8 bis exists at all, is a massive step forward for humanity. Before this was codified, aggression was just a political slur. You called your enemy an aggressor, they called you one, and it meant nothing.
It was just rhetoric.
Exactly. Now we have a measuring stick. It might be difficult to use, and people will argue about the measurements, but at least we have a standard.
It changes the conversation from, I don't like your war, to, your war appears to meet the objective criteria of Article 8 bis.
Precisely. It moves the debate from the realm of pure politics to the realm of law. And that, in the long run, matters a great deal.
It really does. So as we wrap up this deep dive, we started this journey by looking for the architect, the person at the very top.
And I think we found them. We found them in the effective control clause, we found them in the planning and preparation phase, and we trapped them, legally speaking, with the factual circumstances requirement, while taking away their favorite excuse.
We've built a cage out of very specific, very carefully chosen words.
That is the hope of international justice, isn't it? That words, that law, can eventually contain war.
So to you, the listener, the next time you see a conflict erupting on your news feed, the next time you see that breaking news banner, I want you to try to see past the smoke and the immediate chaos. Don't just look at the tanks. Look for the elements we discussed.
Who has effective control here? Who is really in charge? Is this a manifest violation? Look at the scale, look at the gravity, and then ask yourself that final, crucial question. Did the leaders involved know the facts of what they were unleashing?
Be the objective observer yourself.
Exactly. Even if the world can't agree on one, you can use this framework to try and be one. Thanks for diving deep with us today.
It was a pleasure.
We'll see you on the next one.
Welcome to The Debate. Today, we're stripping away the rhetoric of war and really looking at the machinery of justice. We're going to be doing a forensic textual analysis of Article 8 bis, specifically its introduction and the elements of the crime of aggression. This is the legal text that, well, it attempts to do what was once thought impossible: define the supreme international crime and hold state leaders personally liable for it.
It's a text that carries the weight of history, absolutely. But the central question we're wrestling with today isn't really about its moral weight. It's more about the mechanical function. I mean, does Article 8 bis actually build a working engine for accountability? Or by layering threshold upon threshold, specifically regarding who counts as a leader and what counts as a violation, have the drafters built a machine that is just too heavy to ever actually move?
I think, I take let's say, the more optimistic view here. When I read the introduction and the elements in the source material, I don't see barriers. I see guardrails. I see a piece of legal drafting that prioritizes objective reality over the subjective excuses that dictators have used for centuries. I believe this text provides a powerful objective tool for justice precisely because it removes the requirement for perpetrators to make their own legal evaluations. It focuses strictly on the facts.
And I come at it from a very different angle. I think the text is trying so hard to be objective that it becomes exclusionary. We're going to look at the cumulative requirements and the elements, specifically that character, gravity, and scale triad, and I'm going to argue that this creates an incredibly high bar that few real-world conflicts will ever clear. Plus, the restriction of liability to only those with effective control creates a leadership exclusivity that I just don't think reflects how modern wars are started.
Well, let's get into the weeds then. I want to start with what I consider the absolute core of this definition's strength, and that is its rejection of the "I didn't know it was illegal" defense. If you look at the text, specifically introduction point 2, it's just unambiguous. It states clearly, there is no requirement to prove that the perpetrator has made a legal evaluation as to whether the use of armed force was inconsistent with the Charter of the United Nations.
It's a bold sentence, I'll give you that. It certainly cuts off the most obvious escape route.
It does more than that. It fundamentally shifts the burden. It effectively says that ignorance of the law or, a convenient misinterpretation of the UN Charter is not a shield. And this is reinforced by Introduction Point 4, which applies the same logic to the manifest nature of the violation. The prosecution doesn't need to prove that a president or a general sat down with their legal team, debated the UN Charter, and decided, yes, we are definitely violating this. We only need to prove they knew the facts on the ground.
Which is a prosecutor's dream, sure. It streamlines the case.
It's necessary. If we required proof that a leader subjectively believed they were breaking the law, we would never secure a conviction. Every aggressor in history believes they are the hero of their own story. Introduction Point 2 strips that away. It creates a standard of objective liability that is absolutely essential for a crime of this magnitude.
Hold on. That sounds clean on paper, but I think you're glossing over the massive hurdles we have to jump before we even get to the perpetrator's mindset. You're talking about how we judge the person. I want to talk about how we judge the act itself. I'm looking at element 5.
The threshold clause.
The manifest violation clause, exactly. Element 5 states that for an act to be a crime of aggression, it must constitute a manifest violation of the Charter of the United Nations by its character, gravity, and scale.
Right. 3 distinct metrics.
Exactly. But notice the grammar there. It doesn't say character or gravity or scale. It implies a cumulative requirement. You need all 3. And that little word "and" is doing a whole lot of heavy lifting.
I think you're viewing that as a bug, whereas I view it as a feature. We need to define what these terms actually mean to understand why they're there. Gravity refers to the intensity of the violence, the firepower, the casualty count. Scale is usually spatial or temporal. How much territory, how many troops, how long the invasion lasts. And character refers to the nature of the breach itself. Is it a clear violation of sovereignty?
I agree with those definitions, but here's the problem. By making them cumulative, you create a paradox where a horrific act can just slip through the net. Let's play this out. Imagine a state launches a massive, high-intensity bombardment of a neighbor's border city. It's incredibly violent, so it meets gravity. It's a clear violation of sovereignty, so it meets character. But let's say it only lasts for 6 hours and is limited to one city. A defense lawyer is going to argue it lacks scale.
And they might argue that.
And under a strict reading of element 5, they might win. If the violation isn't manifest because it hits 2 out of 3 buttons, the perpetrator walks free. Not because the act wasn't aggression, but because it didn't hit the trifecta. That is where the objective standard becomes a straitjacket.
I think you're being a little too cynical about the judiciary's ability to interpret scale, but more importantly, you're missing the point of element 5. It is there to filter out the noise. We're talking about the crime of crimes. We can't have the International Criminal Court bogged down by, border skirmishes or minor incursions. The character, gravity, and scale requirement ensures that we are only prosecuting the most egregious breaches of international peace.
But where does that leave the victims of the minor incursions?
They have other avenues: state responsibility, reparations, diplomatic sanctions. But for individual criminal liability, for putting a leader in handcuffs, the bar must be high. And this connects right back to Introduction Point 3, which states, the term manifest is an objective qualification. This is crucial. It means manifest isn't about how the victim feels or how the international community reacts politically. It's a legal standard. It prevents the court from being weaponized for political vendettas.
See, I worry that objective qualification is just a fancy way of saying rigid definition. If the objective reality doesn't meet all 3 metrics simultaneously, the definition fails. A manifest violation is the gateway, and if you can't get through that gate because your invasion was massive but lacked character, maybe it was some kind of gray zone operation using unmarked troops, then the objective qualification acts as a barrier to justice.
I disagree that it's a barrier. It's a frame. And within that frame, the text is actually incredibly expansive regarding the types of acts. Introduction Point 1 clarifies that any of the acts referred to in Article 8 bis, paragraph 2, qualify as an act of aggression. So the definition is comprehensive regarding the types of military actions, blockades, bombardments, invasions. The constraints of character, gravity, and scale are simply there to ensure we're applying the supreme crime to supreme acts.
All right, let's assume for a moment that the prosecutor manages to prove the manifest nature. They prove the character, gravity, and scale are all, off the charts. I still have major concerns about the mental element. You praised introduction point 2 earlier, the idea that no legal evaluation is required. But I want to look at the tension between that and element 4.
Go on.
Element 4 requires that the perpetrator was aware of the factual circumstances that establish that such a use of armed force was inconsistent with the charter. Element 6 repeats this for the manifest violation.
Right. Awareness of facts.
But there's a bleeding edge between knowing facts and understanding inconsistency. Let's use an analogy. Imagine a CEO who is cooking the books. They know the fact. I am booking revenue from future sales today. That's a factual circumstance. But they might genuinely believe that under some obscure accounting rule, this is legal. They know the fact, but they don't believe it constitutes fraud.
Okay, I follow the analogy.
Now translate that to war. A leader knows the facts. I am ordering troops across the border to secure a buffer zone. That is the fact. But that leader genuinely believes, perhaps due to bad intelligence or a warped ideology, that this fact constitutes a legal act of anticipatory self-defense. They know the facts, but they do not believe those facts establish an inconsistency with the UN Charter.
And this is where the text is brilliant. Introduction point 2 says, their belief about the legality is irrelevant.
But is it? If element 4 says they must be aware of the factual circumstances that establish the inconsistency, does that imply they need to understand the link? If I know the facts, but I don't see the inconsistency, have I satisfied element 4? You absolutely have. The text separates the facts from the legal evaluation. Using your CEO analogy, the court requires the CEO to know they were booking future sales. That's the fact. The court does not require the CEO to know this violates generally accepted accounting principles. Ignorance of the accounting rules is not a defense. Similarly, a general doesn't need to know this violates Article 2.4 of the Charter. They just need to know I am invading a country that has not attacked us. That is the factual circumstance.
So it's essentially strict liability regarding the law provided they have knowledge of the physical acts?
Precisely. It prevents bad legal advice from becoming a defense. Think about how dangerous the alternative would be. If we allowed a leader to say, my advisors told me it was legal, we would never convict anyone. Introduction point 4 reiterates this. There is no requirement to prove the perpetrator evaluated the manifest nature. If they knew the facts, that's element 6, and the act was objectively manifest, that's element 5, they are liable.
It's aggressive drafting. It basically says, if you are a head of state, you are presumed to know the Charter.
It places the burden on leaders to understand the objective reality of their actions. If you commit an act of aggression, defined in element 3 as the use of armed force against sovereignty, territorial integrity, or political independence, you cannot hide behind a subjective interpretation of the law. You are judged on the facts you knew.
That is a compelling argument for prosecutorial efficiency, but it assumes that factual circumstances are always black and white. In the fog of geopolitical conflict, facts are often disputed. However, let's assume the prosecutor can prove knowledge of the facts. We still run into what I believe is the most restrictive element of all, the definition of the perpetrator.
You're referring to element 2.
Yes. Element 2 strictly limits the crime to a person who was in a position effectively to exercise control over or to direct the political or military action of the state.
And this is necessary because aggression is a state act. Element 3 explicitly defines the act as the use of armed force by a state. A private citizen cannot commit aggression, only a state can. Therefore, logically, only those who hold the reins of the state, those who can effectively exercise control, can be liable. It targets the decision makers.
But effective control is a phrasing that feels stuck in the 20th century. It assumes a vertical hierarchy. The general orders the colonel, who orders the private.
That is how states function.
Is it? What about the modern reality of warfare? What about the private military contractor? What about the billionaire financier who essentially buys the coup? Or the shadow advisor who holds no title but has the president's ear 24/7?
Do they effectively exercise control? Or does this text allow the true architects of war to hide because they don't sit in the official chair?
I think you're interpreting control too narrowly. The text says control over are to direct. That disjunctive or is powerful. A shadow advisor might not direct the military action in a formal sense. They can't sign the order, but if they define the policy, they might be found to exercise control over the political action of the state. The definition is tied to element 1. The perpetrator is someone who planned, prepared, initiated, or executed the act. If you're in the room making the plan, element 2 captures you.
I just don't buy that it's that broad. Effectively to exercise control implies a capacity to stop or start the action. A financier or an advisor can suggest, they can influence, they can threaten to pull funding, but can they effectively control? In a criminal trial where we must prove strictly beyond a reasonable doubt, a defense attorney will tear that apart. They'll say, my client had influence, yes, but not control. The president could have ignored him.
But there has to be a line, doesn't there? I mean, if we broaden it to influence, do we prosecute the lobbyist, the journalist who wrote the pro-war op-ed?
Maybe not the journalist, but certainly the financier who pays for the arms. My worry is that element 2 demands a functional, almost bureaucratic authority. It protects the power behind the throne.
I would frame it differently. The requirement of effective control is there to protect the rank and file. We don't want to prosecute the soldier on the ground or the mid-level bureaucrat for the crime of aggression. They have their own liabilities under war crimes or crimes against humanity if they target civilians. But aggression is the crime of leadership. Element 2 ensures we are aiming at the head of the snake. It focuses on the individuals who actually have the power to violate the sovereignty of another state.
I agree that protecting the rank and file is noble. But my fear is that the definition of effective control, combined with the requirement for manifest violation, creates a Venn diagram where the intersection, the people we can actually convict, is vanishingly small. You need a leader who has absolute formal control, that's element 2, who commits an act that is simultaneously massive in character, gravity, and scale, that's element 5, and whose knowledge of the facts is undeniable, element 6.
And that is exactly as it should be. We are talking about dismantling the immunity of heads of state. That requires a rigorous standard. If the standard were lower, if substantial influence were enough, or if gravity alone were enough, we would see the crime of aggression politicized. Every border dispute would become a criminal indictment. The text of Article 8 bis prevents that.
It prevents politicization, perhaps, but it might also prevent justice. Let's go back to the manifest issue for a second. You argued that manifest is an objective qualification, per introduction point 3. But consider this scenario. A state uses armed force against the political independence of another state, as per element 3, but manages to keep the scale limited. They install a puppet regime and a swift 24-hour coup.
A surgical strike on political independence.
Exactly. Low scale, but high character violation. They have violated the charter, they have compromised independence, yet they might escape the manifest label because the operation was too small and too fast. The objective qualification protects the aggressor in that instance.
I don't see it as protecting the aggressor. I see it as defining the jurisdiction of the court. Not every violation of the UN Charter is a crime of aggression under international criminal law. Illegal, yes. Criminal in this specific sense, no. The text draws a line. The character, gravity, and scale must constitute a manifest violation. It pushes the court to look at the holistic nature of the event. It forces the prosecution to build a case that says, this wasn't just a breach, this was a manifest rupture of international order.
And that brings us back to the evidentiary burden. You rely heavily on introduction points 2 and 4 to ease that burden regarding the mental state. You say we don't need to prove they evaluated the law. But practically, how do you prove element 6, that they were aware of the factual circumstances that establish such a manifest violation, without implicitly discussing their understanding of the scale and gravity?
You prove it through their access to information. Did they receive the intelligence reports? Did they order the troop movements? Did they see the casualty estimates? Those are the factual circumstances. If a leader sees a report saying we are launching a full-scale invasion of country X, they are aware of the facts. Whether they think that invasion is manifestly illegal, is irrelevant under introduction point 4. They knew the scale, they knew the character, and they knew the gravity. That is sufficient.
It sounds clean in theory. Here is the memo, you signed it, you knew the facts. But we know that information flows to leadership are often curated. What if the factual circumstances presented to the leader were manipulated? Element 6 requires the perpetrator to be aware of the circumstances that establish the violation. If they were fed false facts, told that the scale was minor when it was massive, then element 6 is not met.
Now that is an interesting point. If the perpetrator is genuinely deceived about the facts, not the law, but the facts, then yes, element 6 would offer a defense. If a president thinks they are authorizing a small rescue mission and the general executes a full invasion, the president lacked awareness of the factual circumstances. But that returns to element 2. If they have effective control, how can they be unaware of the scale of the action they are controlling?
That assumes a level of competence and transparency in state apparatuses that history suggests is rare. But I can see that for the architects you mentioned, the planners in element 1, that defense would be hard to maintain.
Exactly. The text is designed for the planners. Introduction point 1 reminds us that any of the acts referred to in paragraph 2 qualify. This covers the planning, preparation, initiation, and execution. The text casts a net over the entire timeline of the crime.
It casts a net, yes, but I maintain the mesh of that net is quite wide. By insisting on manifest, defined by the triad of character, gravity, and scale, and by locking liability to effective control, we are looking at a text that prioritizes certainty and protection of state function over broad accountability.
And I would argue that certainty is the prerequisite for accountability. Without the clarity provided by introduction point 3 that manifest is objective, and the dismissal of legal evaluation in introduction point 2, we would have no net at all. We'd have a system paralyzed by subjective defenses. Article 8 bis succeeds because it creates a factual basis for accountability. It protects the sovereignty and political independence of states, as element 3 demands, by ensuring that those who truly direct the machinery of war cannot feign ignorance of the destruction they cause.
I suppose that's the fundamental tension, isn't it? The text certainly highlights the struggle between shielding state leaders from frivolous or politically motivated prosecution and ensuring that those who direct armed force are held to account. The exclusion of legal evaluation is indeed powerful, I won't deny that, but it's only powerful if you can first surmount the wall of manifest violation. And I suspect, given the state of our world, that wall will prove difficult to climb for all but the most catastrophic events.
And perhaps that is the point. International criminal law is the court of last resort for the worst of the worst. By setting the standards where they are, objective, factual, and high, Article 8 bis ensures that when a conviction is secured, it is unassailable.
A high standard for a high crime. It's a coherent logic, I'll give you that, even if it leaves me wanting more avenues for justice.
That's the nature of the law. It draws lines, and Article 8 bis has drawn them with remarkable precision.
Precision, yes. But whether that precision results in justice or impunity, well, that remains the open question.
Indeed. Thank you for listening to The Debate. We hope this deep dive into the text of Article 8 bis has illuminated the complexities of defining the crime of aggression.
Until next time, keep reading the fine print.